Now, a moment before the Attorney General's address, the minority in a news conference in Parliament accused the Attorney General of abusing his office by ordering searches, arrests, and conducting investigations into former government appointees. Here is Deputy Whip Jerry Ahmed Shaibu.
Attorney General is an officer of the court. His interest is to assist the court in dispensing justice when investigators bring their case and evidence. The posture of the new AG undermines this rule. He is no longer acting as an officer of the court, but is instead acting as someone who has conducted his own inquisition, determined guilt of a suspect, and is seeking to force his view or his views on the courts. The practice undermines the role of the Attorney General and undermines the administration of justice. All well-meaning voices that respect the operation of the rule of law should call on it to an end, and to end it now as we speak. We are asking that all well-meaning voices that respect the operation of the rule of law should call on the Attorney General to put an end to this immediately. The Attorney General is not expected to start off by prejudicing an investigation and in his mind conducting an inquisition on suspects. Since when did we have an Attorney General who himself orders arrest, conducts investigations, and examines his own evidence to determine if a prima facie case is being documented or docketed against a suspect? This is highly improper and leads to bias right from the investigation process. Let the court decide the guilt or innocence of suspects. The new approach where the Attorney General seeks to convict political opponents in the court of public opinion before going to the court of competent jurisdiction is an abomination that should not be countenanced. Photographs circulating on social media clearly shows signs of destruction and ransacking, hardly the marks of a lawful and respectful operation. If indeed a court-issued warrant truly existed, why was it not presented to Dr. Addison before or during the raid? Why was brute force used to overpower his private security? Why was the CCTV camera dismantled and taken away? Transparency is a hallmark that ensures lawful enforcement. The failure to follow basic procedure casts doubt on the legality and intent of the operation. No amount of legal contortion or public relations spin can undo the facts. Dr. Addison's home was raided under highly questionable circumstances. If the actions were truly lawful and above board, why did the National Security Coordinator find it necessary to call and apologize to Dr. Addison via the phone of Mr. Richard Jakpa? If there was no wrongdoing with the conduct of the security officers, what exactly was the apology for?
That's the Deputy Whip on the minority side, Jerry Ahmed. And this news conference took place before the AG also addressed the nation on ongoing investigation into some cases. Now let me bring in a former Deputy Attorney General, Alfred Tuanyewa, who joins us on the line. Mr. Tuanyewa, good afternoon. Welcome to the Pulse.
Yeah, good afternoon, my brother.
So let me first pick your initial, assessment, or better still, reaction to all that the AG said this morning. Some say that even updating the nation on ongoing cases and investigation in itself brings about transparency in the way they are going about their work. First, your reaction to what that happened this morning from the AG's office.
All right, thank you very much. Now, today, I'm listening to the learned AG of the Republic. He may want to use a style by updating the public, but such a style must be looked at a bit carefully, especially when it deals with the rights of people who the law presumes to be innocent until proven guilty or they've admitted their guilt. And so what I see as happening today is an attempt by the Attorney General to brief the public. But I hope and pray that this matter is not heard through this kind of medium, that namely through media, even a media trial. I suspect that maybe the AG may want to also cause the attention of the public with respect to what they have done. But will that lead to a fair trial when the accused person is placed before a law court? So these are my initial comments. I thought that when it comes to the rights of accused persons, if you even have hardcore evidence, must present your evidence to a court of law for it to be tested, for completion to be done, and the decision given by the court.
Right. That is why I also have a bit of a difficulty. Perhaps you can help educate us because you are a lawyer and you've served in that office before. Now, listening to the Attorney General this morning, Dr. Dominic Kanyine, he comes to the firm conclusion that Mr. Duboahim is guilty, virtually, pronouncing that on him during that news conference. Is it standard practice? Because the case is yet to get to court. The court is yet to pronounce. I mean, we've even yet to hear from the side of the person who's been arrested. But emphatically, the AG concludes that the man engaged in a criminal enterprise, and he goes on to point what he used the money for, when we've not heard from the other side.
I agree with you with the question that you just posed. It is not normal for you to pronounce the guilt of an accused person when the law says that he should be presumed innocent until proven guilty or has pleaded guilty to the specific count. And so I have not encountered such a situation where since 1993 that we started this democratic regime, where you have the Attorney General or a rep Attorney General addressing the media and drawing conclusions that he came up with today. So it's something new, as you also observed. It's also something new that you all have to be worried about.
So in an environment where the case is yet to get to court, to what extent does it put pressure on the judges that may sit on this case, knowing whether the AG, and rightly so, appears to have taken a firm position that he expects this kind of outcome?
Yes, exactly. It's one of the things that I'm worried about. I recall that the question was posed to the learned Attorney General on the issue of bail, and he tried to justify or answer that question by indicating that from the evidence that they have and the conduct of the accused person and what the public know right now, the accused person is someone when granted bail may even abscond. So he's in a way taking the power of a court to grant bail from a specific court. So if this matter is played before a court and a judge, after looking at the evidence, decides to grant bail, then there's an attempt on the part of the AG to pitch the court against the public or the public against the court. And so the public can go, the judge was wrong because the AG said he has to be remanded because it's likely that you abscond. If the AG has any reservations as to whether a person should be granted bail or not, that reservation or those arguments you have to put up when the case is brought to court. And the grant of bail is at the discretion of a judge, but not the prosecutor. And so that power that the AG today sought to arrogate himself, something that I think I disagree with him respectfully.
All right. So, I mean, from a legal point of view, what do you expect Mr. Duboahim and his lawyers to do now that they've been put in the public light as, somebody guilty of an offense that he's yet to respond?
Yes, I think lawyers for Mr. Duboahim, they may have the tapes and they may want to take certain decisions on it. I may not be able to offer a specific opinion to them on it. But my advice is that moving forward, the AG will have to review such cases. If you recall, during our time, we never held a press conference to give out the evidence that we have in any specific matter. With respect to all those high-profile cases that we had, there wasn't a single moment that we came out to give the evidence before going to court. We went to court, level charges, came out with the facts, filed our witness statements. At least if those things are filed, they probably get to know. But we never chose that medium to address the media before putting a case before a law court.
This Mr. Dubois matter, I mean, the sequence of events points to matters that took place between 2020, 2021, up until the time he exited office. Did any of this come to your attention?
Not at all. Not at all. I am not holding brief for Mr. Dubois, but I don't see whereby you also condemn him. Because what the AG has done is to put the side of the story, because you have this kind of theory of the Attorney General, the theory of an accused person. Until you listen to both sides, you're unable to draw conclusions. But between the period that you have stipulated, nothing of that came to my attention as a deputy AG or to the office.
But if indeed, for now, we can live with the AG's position that Mr. Dubois, while serving as Director General of the National Signals Bureau, set up a company that virtually was doing the same thing that the taxpayer was paying him to do. Doesn't that amount to conflicts if indeed this is what it is?
So I do not want to run on assumption. I have not heard the side of Mr. Dubois. And because I don't have that information, it is difficult for me to draw conclusions. I mean, it's all usually said in Akan language that fire will let you know whether a certain piece of cassava is good or bad. Literally, if you have any piece of evidence and you test it in court and it's accepted by the court, that's what you can say, yes, this is proper evidence. For all what you've heard today, I mean, they are mere facts, mere allegations. They become evidence when they are tendered in court and then tested in the court examination. The court will then make a conclusion of it. So I don't want to pass any judgment for now.
And then the other matter, secondly, is it also right for the AG to say that a person of interest in a matter of the Sky Train is currently in Senegal and may have absconded, even though he also makes the point that the person has given an indication that he will be in the country within a certain period of time? The assumption being created is that he's in a country which has no extradition treaty with Ghana, meaning the possibility that he is hiding or evading justice stands. Is it right for him to come to such a conclusion?
I also disagree with you respectfully. I mean, if the person has indicated to you that he's in a specific jurisdiction or in another country, but he'll be coming, you wait until he tells you that he's no more coming. And if he does not come, then you may want to activate other international instruments or other laws to get him back to Ghana. And so, if the age, that portion, unfortunately, I didn't hear that portion because I was engaged in something else. But if that individual has indicated to you that he'll be back to face justice, then how can you be saying that he's trying to evade justice?
The performance of the Attorney General's department in the last 8 years was also in focus. Now, he concludes by saying that the AG office went to court on several occasions without even supporting any supporting evidence to get the conviction that the AG wanted. And even makes the point that the entire country was turned into a crime scene in the last 8 years, virtually questioning the competence of the office you once held as Deputy AG in the last 8 years, that you rushed to court when you didn't even have supporting evidence. Sometimes you have to even rely on those who are prosecuting to help you win your cases.
That is quite unfortunate. Such a statement coming from the Learned AG is quite unfortunate. I mean, as a senior member at the bar, for that matter, as the official leader of the bar, the AG is aware of the fact that those cases that he entered MP, those cases that he filed notice of withdrawal, we had closed our cases apart from, I think, one of them, and the court had made a determination that these persons had a case to answer. So what is he saying? If you go to court as a prosecutor, you have to mount your prosecution, close your case for the court to make a determination whether you have made a case. And when the court makes a determination that you have made a prima facie case for an accused person to answer, if an accused person decides not to open his defense, a court can go ahead, convict him, and sentence him. And so I disagree with him. We did painstaking prosecution. We rely on investigations properly conducted by state institutions who were not going to the media. We will not definitely, at the time that we're in office, will not get someone arrested before we get evidence to take the person to court. I mean, if you say so, if you can mention one case where we went to court and then we didn't have the evidence. If we didn't have the evidence, how come that the court said those accused persons had a case to answer? I mean, you may reach out to him for him to respond because he entered NP and filed notice of withdrawal in almost all the cases that we spend the taxpayers' money to prosecute in court. And we never rushed because in terms of criminal prosecution, you do not rush with investigations. You must dot the I's, cross the T's to ensure that you do not infringe on the rights of the accused person, to ensure that when you're prosecuting a case, your evidence is solid and up to scratch and can meet the test of legal scrutiny. That's what we did. And I think posterity will be the best judge. But they are in office for a little 2 months. Let's see what happens.
So therefore, you expect the AG to stop the commentary and go to court if he has evidence to back the claims against those that have been arrested by the state security agencies?
That is the work of the Attorney General. That is why the president has appointed him. That is why the taxpayer is paying him. That is why, at the end of the day, he's accountable to the people of Ghana. If he has evidence, he must go to court and prosecute the case. If he thinks that by going public, he may want to set out the public against the court, with the event that an outcome comes, or there's an outcome that's not favorable to their court, and the public may say, oh, this is what happened. I mean, maybe I'm not trying to think that way, but who knows? But I have not, since 1992 that we started this democratic journey, had any Attorney General addressing the media, giving evidence, and concluding on evidence that he has.
Finally, before I let you go, over the weekend I heard you on Newsfile on this controversial issue of whether the former governor of the central bank home was raided by operatives of the national security. Now, we have just secured a court order signed by Justice Ali Baba Abuturium. This is the Republic versus NS Kwamena Yidu Adesim, an S-party application. And it's a search and arrest warrant. And some of the fine details include, let me just run through. It is hereby ordered that the unnumbered house of subjects, Mr. Addison, who reside at the airport residential area in Accra, be searched, arrested by the appropriate security agencies for the purpose of finding, also preserving items subject to have been obtained or procured through criminal conduct. It is also ordered that any item of evidential value to the investigation being conducted, if found on or at the above named premises, should be searched, retrieved, and preserved by the agency or agencies to assist in the investigation. It is further ordered that any person or persons found in the premises who may be engaged in any form of illegal activity should also be arrested to assist in investigation. With this order by the court, will you say that the national security agencies acted within law?
If what you are reading is a warrant from the court, and I believe so, then they acted within the law. But the question is, you can have a lawful warrant, but in the execution of that warrant, you may act unlawfully. So even if they had this warrant, which I do not doubt, did they execute the warrant within the remit of the law? If they did, so if they didn't do it, the question may come up.
The AG said that some conversation went on between the national security operatives that went to his home and then the Mr. Addison, and he's daring the minority leader to keep quiet, otherwise he will make it public. Will you suggest that is made public to bring clarity to the matter, especially what happened in the home when the national security operatives entered?
It is very neat for me to bring out. The Attorney General is the senior person. This is not the first time that he has assumed that position. The last time he was there, he was the deputy. It's not been created the position of an attorney general. It is not everything that you want to say, tell me, and let me bring it to the public. People may want to criticize you. If you are criticized, you take it. But if the person who was searched comes out to say that, indeed, the search was done A, B, C, D, and you think that wasn't the case, he also has the right to respond.
Okay.
But during all those things are not things that I think we should put our minds on. The question that to answer is, was the warrant executed in accordance with law? If the answer is yes, let's move on. If the answer is no, let's make sure that in warrant, when it comes to the execution, we do it right.
And then finally, on a personal note, you think that government is just after former government officials? We've seen a tall list of people who may be questioned on one issue or the other, including your former boss, Godfrey Eboadami.
You see, if you hold a public office, it is expected that you be called upon to render account. And those of us who are former government appointees were very mindful of this one. But that same process cannot be used to witch hunt people. And so if they have evidence that any former government appointee has done something untoward, they can go ahead, investigate the person in accordance with law. That's so simple. We are not saying that if you have done something untoward, they should be left because they heard the political position. No.
We'll leave it here for... Okay.
But that process must be in accordance with law. And if people have not done anything untoward, and you decide to embark on various activities to embarrass them, I mean, such individuals will not sit down. They also fight back legally.
Okay. Afetwa, thank you so much for your time this afternoon. He is a former Deputy Attorney General and Justice Minister during the Akufo-Addo, in fact, in the second half of the Akufo-Addo administration.